Alright, this is my response. The library is trying to quash my lawsuit because they claim it's outside of the time limit. It's time barred because the Peremptory law says that it's 1 year, and so I make my response. It's mostly just me plugging all the information I could find into ChatGPT 01, the latest one, updated just a couple days ago, and letting it put out this response in the form of a motion. So it's plaintiff's memorandum in opposition to the defendant's peremptory exception of prescription. Plaintiff respectfully submits this memorandum in opposition to defendant's peremptory exception of prescription. The library's argument rests upon an outdated 1-year prescriptive period and failed to acknowledge the Louisiana legislature's deliberate and controlling amendment extending the prescriptive period for delictual actions to 2 years. Further, the library disregards that the continuing harm doctrine and the indefinite nature of the ban sustained plaintiffs or my claim and defeat the library's attempt to bar me on prescription grounds. I argue that the library claims, including defamation, intentional infliction of an emotional IIED, and violations of Louisiana's open meetings law, are prescribed based on the old 1-year deadline. However, as of July 1st, 2024, the Louisiana legislature amended the Civil Code 3493.1 to extend the prescriptive period for delictual actions to 2 years. Additionally, the ongoing indefinite ban constitutes a continuing tort under well-settled Louisiana jurisprudence, preventing the running of prescription until the wrongful conduct ceases. My heavy reliance on the previously applicable 1-year period. The library's reliance. It's misplaced, especially in light of the continuing harm inflicted upon my constitutional and legal interests. Courts have a duty to apply the current controlling law and uphold equitable principles, not to allow procedural technicalities to shield an ongoing wrong. Legislative change to Louisiana Civil Code Article 3493.1 controls this case. The library repeatedly cites the original 1-year prescriptive period for delictual claims, yet that period is no longer the law. The Louisiana legislature explicitly amended Louisiana Civil Code extending the prescriptive period to 2 years. And I feel like this is a repeat suddenly. I'm not happy about that. This amendment, I already sent it too. This amendment reflects a clear legislative judgment that the prior 1-year time frame was inadequate, aligning Louisiana's law with national norms and ensuring fairness for me, who need more time to prepare and file legitimate claims. Library's reliance on pre-2024 appellate decisions upholding a 1-year period is unavailing. Courts must apply the law as it currently stands. See Hall v. Zen. Courts apply current substantive law to ongoing disputes where the legislator's intent is manifest. The will of the people. The new 2-year prescriptive period governs my claims, making the library's arguments about 1-year prescription inapposite. I'm not familiar with that word. The continuing tort doctrine defeats the library's prescription argument. The continuing tort doctrine. Beyond the legislative changes, my injuries are continuing in nature. The library's indefinite lifetime ban is not a discrete, closed-off event from the past. It is an ongoing deprivation of my rights and interest. Every single day it remains in effect. I can't believe that the library is making me have to argue this. Under Louisiana law, when wrongful conduct and its harmful effects are continuous, prescription does not commence until the conduct ceases. The Louisiana Supreme Court has long recognized the continuing tort doctrine. In Bustamante v. Tucker, the court held that prescription does not begin to run until the wrongful conduct ends if the injurious acts are continuous and create cumulative damages. Similarly, South Central Bell Telephone v. Texaco illustrates that where the harm is ongoing, the prescriptive clock does not start. My exclusion from the library is not a one-time harm. It is a perpetual state that repeatedly injures me, my right to access public resources, my reputation, and my emotional well-being. Each day I am excluded, the wrong is renewed. Courts applying the continuing tort doctrine have recognized that where the complaint of harm is ongoing, strict application of a past cutoff date is both inequitable and contrary to law. The library's attempt to treat my harm as if it ended on April 18, 2022 is factually incorrect. The ban did not expire, was not lifted, and was not limited in duration. It remains in place, continuously injuring me. Thus, prescription cannot have expired on those claims. The library's reliance on stale law and expired rulings is unpersuasive. Library cites pre-amendment authorities insisting that my claims are prescribed, but these cases, however, before the legislative extension do not control here. Courts have a duty to follow current statutory law. The newly established 2-year period directly supersedes prior rulings and enforced a 1-year limitation. Moreover, the library fails to grapple with the well-established principles that in the case of ongoing harm, courts will not penalize me who challenge an enduring violation. The legislator, I feel like I'm being penalized by the way the court already responded. The legislator's amendment and Louisiana's continuing tort jurisprudence coexist to ensure that ongoing harms are not unjustly immunized by rigid adherence to outdated deadlines. Open meetings law and continuing procedural violations. With regard to my claim under Louisiana's open meetings law, the library argues that a 60-day period bars relief. This assertion overlooks the possibility that no properly noticed meeting action occurred at all, or that the alleged violations continued beyond any single date. If the library never afforded proper public process or engaged in ongoing procedural defects, the triggering event for prescription or preemption may never have started. Courts have recognized that when the triggering procedural event never properly occurs, the time clock never begins to run. See Rogers v. Tangapaho. Suits challenging meeting-related actions must be considered in light of whether required procedures were followed. The defendant's arguments the library's arguments ignore these crucial factual and legal nuances. Equitable considerations in public policy supporting denying the library's exception. The library's approach would effectively reward it for imposing a permanent ban with no clear termination. Such a ban, especially if imposed without due process or legitimate documented reasons, can violate constitutional rights. Libraries are generally recognized as limited public forums under the First Amendment. See Kramer v. Bureau of Police for Town of Morriston. Although a federal case, it illustrates how courts understand the constitutional significance of free access to a public library's resources. The indefinite denial of access to public information not only injures me continuously, but also offends public policy and fundamental fairness. By extending the prescriptive period to 2 years, the legislature signals its intent to provide litigants with a more reasonable time frame to assert their claims, especially in cases where the harm is not readily concluded or discovered within a shorter window. For these reasons, the library's peremptory exception of prescription must be denied. The legislature's amendment to Louisiana Civil Code Article 3493.1 establishes a 2-year prescriptive period for plaintiffs' dialectual claims. The ongoing nature of the harm, as recognized by the Louisiana Supreme Court's continuing tort doctrine, prevents prescription from even commencing until the ban ends. Defendants' reliance on outdated legal standards and disregard for continuing harm cannot override the plain language of the amended statute, the sound jurisprudence on ongoing injuries, or the principles of equity and public policy that supports allowing plaintiffs' claims to proceed, or my claims to proceed. I therefore respectfully request that this court deny the library's exception of prescription in its entirety and allow the claims to be adjudicated on their merits.